Mexican, Yo-Yo, and Vanessa.
All right, Pandora Bear on YouTube asks, I'm a citizen and filed the I-130 for my brother and children in Iran. My mother just filed the N-400. If she's granted citizenship, will it be better to transfer the brother's case to my mother?
Wait, go again?
So I'm a citizen and filed the I-130 for my brother and children in Iran. My mother just filed the N-400, so if she's granted citizenship, will it be better to transfer the brother's case to the mother? No, you can't.
There's no such thing as transfer case. So the mother can file, but it's going to be a long time.
So just keep it as
I don't know if this brother is married, and I don't know what her priority date is for her brother. So if she filed, for example, a decade ago, I'm sure it'll go fast. It depends what the priority dates are.
Okay.
Okay, Aleem Aga on Facebook. I am a U.S. citizen filing for my father. On May 1st, I made a payment and received confirmation from the NVC. Today, I received a letter explaining that all the payments and documents have been received and to wait to schedule an interview. But only one payment, $125, is taken from my account, not the $325 visa fees. Why did this happen?
Because Trump has a prohibition on immigrant visas right now.
29 Super C on YouTube asks, any update on the litigation action case against the temporary immigration ban that was in court in Washington, D.C.?
I do not, unfortunately, have one. I don't know. They were supposed to be in court this week, but I didn't hear what happened. But obviously, it's still in place. There was no injunction. I know that.
Cindy Requena on YouTube. I received my RFE to resend my medical exam because it was expired, so they could make a final decision on my AOS, which my daughter is petitioning for me. About how long will it take for me to receive a response from USCIS? There it is.
Magic 8 Ball.
We really might need to consider this segment.
Magic 8 Ball. This woman submitted some documents to immigration, wants to know when immigration is going to respond. Will they respond by November 30th? Let's pick a date, Magic 8 Ball, because we have to ask a yes or no question. It says concentrate and ask again. I wasn't concentrating. It's Friday. Magic 8 Ball, please tell me. This woman needs to know, and only I would know, and I said I wouldn't know, but the Magic 8 Ball would know when she's going to get a letter from immigration. Will it be before November 30th? It says ask again later. The Magic 8 Ball doesn't even know this stuff. I'm just reading what it says.
All right. Manny on Facebook asks, if I come to the U.S. with a returning resident SB1 visa, will immigration subject me to a public charge test?
Yes, they will, because if you're out of the country for more than 6 months, you potentially could have a public charge test.
Najla Danishyar on YouTube. My dad will be a citizen in 2 years. He's gonna petition for my widowed sister and her 3 kids soon, which usually takes 5+ years. Once my dad gets his citizenship, will that make the process faster?
Only by about a year, unfortunately.
Arnett Slobo on YouTube asks, my sister had an interview more than a year ago, and we haven't heard anything yet from USCIS. It was a marriage-based interview. Can she file under the new law that was given to Liberians because she is qualified?
Yes,
we asked that.
We asked that yesterday. We're getting yesterday's questions, I think. Keep going.
Bpin Donna Wade on Facebook. If someone marries a U.S. citizen but is living in his home country and the U.S. spouse doesn't want to file papers, will this marriage be called void marriage, or are they still married? Also, can the foreign spouse file the VAWA petition on his own in this situation?
You can
appreciate your expertise.
You can be a VAWA applicant from another country. You don't have to be physically in the United States to have been abused. Emotionally, or if your U.S. citizen spouse went to your home country and physically abused you, or you could have been abused emotionally. If it's a civil marriage, it's a real marriage. There's no void marriage. I mean, unless you get an annulment. I mean, you can get an annulment. I guess somebody can get an annulment and prove to a judge that it was a, marriage of convenience and business, and then a judge can give you an annulment based on the fact that it's a void marriage, but you just can't say it's a void marriage.
Okay, Chanel Simpson on Facebook asked, my wife and I have been married for approximately 1 year, and she forgot to change her last name on the joint bank account, which shows that we're living at the same physical address.
Yeah,
Will this be a problem?
He called our show. I spoke to him about it. The answer is not a problem.
Okay, so this one's from Joan Conwell on Facebook. What if a daughter files for her mother from Jamaica and after 3 years she is mistreating the mother in the house? The mother is unable to provide for herself due to sickness. Can there be any legal action taken against the daughter?
Yeah, there's elder abuse, and also you can file a VAWA as an abused parent by an adult child. So if the mother doesn't have a green card, she could file a VAWA case against the child who's abusing her. And then there are obvious in every state, in every jurisdiction in the United States, there's elder abuse laws for criminal conduct against that person.
Nana Ama Otiwa on Facebook asked, my sister is a 2-year green card holder. She's in removal proceedings and now she's lost her job. She would like to know if she can apply for unemployment benefits without affecting her immigration case.
I don't know what she's doing in removal proceedings. I need to know a lot more.
Okay, God's got me on YouTube. I have a pending AOS applied for EAD renewal. Got a response that they're reviewing and doing a background check. What does this mean? And can I use the receipt notice to renew my driver's license?
You can use the receipt notice to try to renew your driver's license. Your work authorization is valid for 180 days if it's pending. It means exactly what they say. They're reviewing your case. It's under review. Now, review could mean they're waiting on your fingerprints to clear. Review could mean they believe that this is not a real marriage and they'll call you back for a Stokes interview. Review could mean, you know what, you're in a pile to be reviewed and we're busy and we'll get to it eventually. So review could mean lots of different things. I think your particular question is what's going to happen. And my guess is what's going to happen is you're going to be called for a second interview and you're going to get a Stokes interview.
Okay, Amy on Facebook asked, USCIS filed an I-130 for my husband in Brazil. We know he'll be denied at his interview due to overstaying his B2 tourist visa. Are we able to file the I-601 before the interview, or do we need to wait for his denial at the interview?
If he's already out of the country, you got to wait for the denial. If he's physically in America before he leaves, you would do a 601A provisional waiver.
Bright Astuce on Facebook. I actually lost my 10-year green card and I'm thinking about applying for citizenship instead of replacing the green card. I also don't have a copy of my green card. What are your thoughts?
File your citizenship. You obviously don't need a green card because you've been living without it. And just because you lost your green card doesn't mean you're not a lawful resident. And you don't need, you just submit your citizenship, but you're a lawful resident. End of story. You just don't have evidence in that particular green card.
Okay, Olukokun Adeji on YouTube asks, why can't a green card holder who would soon be a citizen file for his spouse of 2 years living with her in the USA? Is there a law that says only citizens can file for adjustment of their spouse?
Yes, there is a law that says if you're married to a U.S. citizen, you're an immediate relative, which means that as soon as you are married and that relationship exists, you're immediately eligible for a green card. Immediate relatives who are spouses of U.S. citizens, children under the age of 21 of U.S. citizens, and parents of U.S. citizens and that U.S. citizen is over the age of 21. They're all immediate relatives, and under the law, immediate relatives are allowed to overstay on their visa and still be able to adjust. When you are married to a permanent resident, you're in the F2A category, you're a quota immigrant. There's just a certain number of green cards given out any particular year. As a quota immigrant, you either have to be 245I or in legal status to adjust your status. At this present moment, there is no quota on F2As being married to a lawful permanent resident. So as a result, you can adjust your status as long as your spouse is in legal status. Once she overstays her time, unless she's 245I, she would not be eligible to adjust her status until you become a citizen, because then she becomes an immediate relative. Make sense? Noted. Did you take that all down, Vanessa?
I was focused, okay. Laser focused.
Laser.
In my notepad.
Laser.
The next one comes from Obina Nakawacha on YouTube. Sorry if I chopped that up. How does a work permit for a K-1 visa work? A work permit on arrival?
Well, you're supposed to be work authorized for 90 days when you come on a K-1, but realistically, you have to file for the work permit. It takes more than 90 days to get the work permit. So realistically, you're not going to get a work permit when you arrive on the K-1. When you get married, you file an adjustment. That's when you'll get your work permit.
Okay, Grams Tetej Dej on Facebook asked, can a retired U.S. citizen sponsor someone for a green card?
Yeah. Could be a spouse, could be a child. Maybe that retired U.S. citizen's an employer. Well, they're retired, so they can't be an employer.
Okay, the next one comes from Lord Beerus Sama on YouTube. Can I submit a new I-A64 form at the interview if my current sponsor lost his job due to COVID-19?
Yes.
Okay, Gum Pop Candace on YouTube asks, I'm a green card holder, which I achieved through marriage. If I'm convicted of aggravated assault and I have two minor children, can I still be deported? I've been in the U.S. for 2 years and I'm divorced.
If you are convicted of an assault within the first 5 years of your entry into America, that's a crime of moral turpitude unless it's a petty offense, which means that it would be a misdemeanor assault and you didn't do less than 180 days in jail. Other than that, you're going to get deported for committing a crime within your first 7 years of entry into America.
The next one comes from Miguel Vallejo on YouTube. What would hold more weight if I was found incompetent or that I have a child that needs me because his mom abandoned him?
Child or incompetent? Hold more weight for what? What are we weighing?
I wasn't sure what we're scaling.
I don't know what we're well, on one side of the scale there's incompetence.
I'm not
and
sure
on the
what
other,
the problem is in terms of the
then,
scale.
Yeah, I'm not sure what we're weighing. What are we weighing?
Yeah, we're not what we're weighing.
I don't know what the hell. I don't know.
What's the scale to the question?
I don't know. I mean, they're both obviously sound like bad problems,
Yeah.
but I don't know what we're weighing.
I was trying to think,
what?
but
Why? For what? A waiver? A waiver? But I need to know more. I assume for a waiver, but I need to know a lot more.
all right. Chelsea Ann Francis on Facebook asks, immigration requires 3 tax returns, but I only have 2. What can I do from here?
File with the 2.
Donna Lindo on YouTube. I am planning to file for my daughter and her 2 children. Is it true that filing for my children first can make the process longer, or I should file for my daughter first?
Filing for her children?
Yeah, it says I am planning to file for my daughter and her 2 children.
How old is if the daughter's over 21, you include the children on your daughter's case so they'll all come together.
Avi B on YouTube asks, I'm married to a U.S. citizen, or I married a U.S. citizen in April 2019, but separated in June 2019 because of an abusive wife. My friend applied for marriage annulment, nullifying, still processing. My friend also applied for asylum in January 2020, and I received asylum EAD in August. At present, both marriage and...
Wait. We talking about his friend, or we talking about this guy? This is the first time I've ever actually heard somebody say, "I'm asking a question for a friend." I
think it's for both. If we finish reading it, I think it'll go. It's a question for both of them.
All right.
I believe so. So I'll start over.
All right. So one person's getting an annulment.
Huh?
Somebody's getting an annulment.
Yeah,
so
the
do you
friend.
want me to start over?
All right, start again. No, start again.
Okay. I married a U.S. citizen in April 2019, but separated in June 2019 because of an abusive wife. My friend applied for a marriage annulment, nullifying, Still processing. My friend also applied for asylum in January 2020, and I received asylum EAD in August. At present, both marriage annulment asylum are pending. Are there any chances of filing and winning a VAWA case with while these are still processing and without giving up asylum EAD? Can we both apply? Asylum and VAWA at the same time?
Yeah, it is for both.
I
It sounds like they're in a similar
but it just went back and
predicament.
forth. I understand now. Thank you, Yo-Yo. The answer is you can file a VAWA and have a pending asylum at the same time. What you can't do is file an adjustment and have an asylum at the same time. So my advice would be continue with the asylum, file the VAWA. If you're going through an annulment, fight that annulment, because an annulment means the marriage never happened and you have to prove it was a real marriage. But if the marriage never happened, then you can't prove it's a real marriage. So if you plan on filing as an abused spouse and the abuser files for an annulment, you have to defend that annulment and countersue for a divorce.
Sounds like a process. Next one comes from Bobin Guacho on YouTube. I want to know if I can use my passport, my expired green card. Wait, had I read that one? I think that seems like the same question. If my passport, my expired green card, and the receipt from USCIS to travel and come back. No, we hadn't answered that one.
You want to be able to use your expired green card to travel? You cannot. You need a stamp in your passport that says I-551, or you need a valid green card. You're not going to be allowed on the airplane.
Okay, Lord Beru Sama on YouTube asks, can I bring a new I-864 sponsor form to my interview if my current sponsor lost his job due to COVID-19?
Yes, we answered that one.
Manny Arroya Raj on Facebook. I am a green card holder who stayed out of the country for more than 6 months due to COVID, and I returned back late. Will I be subject to a public charge test?
Yes.
Even if I
have an SB1, the answer is yes. If you spend more than 6 months outside the United States, you could be subject to a public charge test. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.